Hello, and thank you for clicking on our link and watching the next installment of our video series. This particular episode is dealing with commercial receivership in the state of Colorado. You can link to this and other videos at commercialreceiver.org, and you can learn more about our speaker there through links as well. Today, our expert on the commercial receivership process in Colorado is Adam Hirsch. Adam is a partner in the Finance and Acquisitions Department of Davis, Graham, and Stubbs in Denver, Colorado. Adam focuses his practice on representing clients across the U.S. in all aspects of bankruptcy, business restructuring, and related transactions. He advises secured and unsecured lenders, DIP lenders, Chapter 11 plan sponsors, acquirers of assets in Section 363 asset sales, and others. He also represents clients in transactional matters involving financially distressed parties and in reorganizations under Chapter 11. Mr. Hirsch is recognized for his expertise in insolvency law, including commercial receiverships and bankruptcy, as well as other insolvency law processes. He received his JD from Tulane University Law School. He was a partner at Kudak Rock in their Denver office, and before that was at a large New York law firm where he represented clients in a range of bankruptcy matters. A link to Mr. Hirsch's biography can be found at commercialreceiver.org, and there you'll also find additional materials dealing with receiverships in Colorado, how they function, how they don't function, and what are the best practices in terms of maximizing the utility of a receivership in that state. So I'd like to begin. Thank you, Adam, for being with us today. And I'd like to just get a general overview. So if you could tell us from a high level perspective, how does a commercial receivership work in Colorado?
Thanks for the opportunity to do this. In Colorado is what I characterize as a largely unstructured state from a receivership perspective, in terms of the statutory framework that's available for it. So typically, there is a rule that's in place, Rule 66, which is analogous to a federal rule. But the state court rule is a little bit more robust, but essentially what it boils down to is if you have equitable grounds for receivership, among others, then you can seek to have a receiver appointed in Colorado. Typically, the process from a very high level is you file a complaint. You're actually commencing litigation in state court. And in that complaint, you assert a claim for relief for appointment of a receiver. With your complaint, since you're typically trying to do that in a shorter time frame, you'd also include a motion for appointment. Sometimes that can be ex parte, sometimes it doesn't have to be though. And it would be verified, meaning sworn to by the party itself seeking the appointment. And then from there, the court would enter an order, assuming that you get the receiver, and you're off to the races. One interesting point to point out, as far as Colorado is concerned, and this is actually codified in the rule, is that receivership, we are a single action state, so you don't need to necessarily couple it with other claims for relief, although for various reasons you may do that. But you can seek as a bare remedy the appointment of a receiver in your complaint.
So how do you select a receiver in Colorado? In some states, there's a panel. In others, the plaintiff selects. Where I live in Missouri, the plaintiff basically makes that recommendation. There could be a debate over it, but that's how the receiver is selected. How do they do it in Colorado?
In Colorado, it's that way. The party seeking the appointment of the receiver will recommend the receiver in their motion to have the appointment done. And they'll typically attach a bio with their recommended receiver. And it's up to the court as to whether or not the court selects that receiver for appointment. Other parties in interest may oppose it. They may propose their own receiver if for some reason they don't like the receiver that's proposed, or the court may. As a practical matter, typically, especially if you're seeking on an ex parte basis, the receiver that's recommended is typically the one that's at least initially appointed. Although later someone may come back and try to seek to have a substitute receiver appointed instead, or the receivership terminated.
How much notice does the target of the receivership typically get before there's a hearing on the appointment?
It may be none. If you're doing, you can do it in Colorado on an ex parte basis. A lot of times, and I'll typically try and get this, if you're doing it as a lender to a borrower, and you have some sort of, you've gone under a forbearance agreement, or in your loan documents, or certainly in a deed of trust if it's a real estate deal, it wouldn't necessarily be uncommon to have a contractual right to have a receiver appointed after an event of default. And typically, when drafting those provisions, I'll make sure that the borrower consents to the appointment on an ex parte basis, so that you can go ahead and proceed with that. Short of that, you can certainly seek it on your own on no notice, if you have grounds to do so. You're concerned about waste, you're concerned about the principles of the company, absconding with assets or something like that, in which case no notice is permissible to initially get the receivership order. Now, of course, that's all subject to review and change once the other party ultimately gets notice of the proposed appointment.
So I know when I do a receivership case, the appointment order is a very extensive order. It can run 20, 30 pages at times. Maybe that's unnecessary, maybe not. It's always tailored to the case. But other states have forms. How does Colorado's appointment orders, what do they look like?
Colorado is more like what you're familiar with. And because we don't have a robust statutory structure that says what a receiver's powers are and what they are not, you want a more robust receivership order, 15, 20 pages. And my view on this is it usually takes as long as it takes to say what you need to say. But the more that you can put into your receivership order to avoid a lack of clarity or any kind of ambiguity about what the receivership's powers are, what the receiver's powers are, or what the scope of the receiver's job is, the more you can get in that order, the better off you are.
Okay, and so what is the standard? There are some places where you need insolvency, others contractual rights can get you there. Is there a single defined standard that the courts look to appoint a receiver?
The short answer is yes. Initially, as a practical matter, it's an equitable remedy, and so there is case law in this district or in the state that if you have a contractual right to receiver, that's very, very difficult to fight, because you've effectively agreed to it. And the Colorado Court of Appeals came out with a decision on that front quite a bit of time ago. And so the contractual right, it's pretty easy to get done. If you've got, it's short of a contractual right, the way the Rule 66 in Colorado works is it outlines in 3 different cases kind of what the standard is. If you're trying to do a pre-judgment, you would need to show some kind of waste or something like that. If you're trying to do a post-judgment, maybe a little bit easier for collection effort purposes. If you're trying to do it, and then the third is simply in the equitable interest of the parties involved. So that is somewhat of an amorphous standard, and since we're based largely on common law, it's up to the lawyers to really do a good job of arguing what the equitable grounds to having a receiver appointed are, in recognition of the fact that it's a drastic remedy.
So you're getting your receiver appointed, and you've met the standard. You've only identified a defendant in the case, but there's other stakeholders, obviously, whether they're secured or unsecured creditors or business partners. Who gets notice in Colorado and who can participate in the case?
As an initial matter, notice is typically given just to the parties in the action, because you're commencing it with a complaint. Once the receiver is appointed, the receiver is an officer of the court, and you'll want to then notify people, or he'll want to notify people as broadly as possible, because, for example, certain things you may have in your receivership order, injunctions that would prohibit officers, directors, other employees from doing things that would interfere with receivership property, or other parties from doing that for that matter. So you would want to give them, once the receivership order is entered, notice so that they then don't do things that would frustrate your efforts on receivership.
And so once you get the receiver appointed and you're giving this notice, is there also some kind of a stay that goes into effect?
Not automatically. There's no statutory stay like you'd have in bankruptcy. Mm-hmm. But however, your receivership order will typically include injunction language that will enjoin various parties from doing certain activities, which is mentioned, that would somehow interfere with receivership property, which kind of mimics the stay. But again, that gets to the point of having a robust receivership order. And so you want to make sure that it's clear, and that you notify the parties so that they don't do things that interfere with receivership property.
And in Colorado, is a receivership always a liquidating process, or are there operating receivers who are going to manage a functioning company for at least a time?
No, sorry, I didn't interrupt. Yeah, there are operating receivers. There's no process that says it has to be a liquidating. There's no prohibition on that. Liquidating receivers probably tend to be a little more common, at least in my experience. But a lot of times, in one case, it kind of comes up a lot in terms of an operating receivership, and there is a statute that implements this. It doesn't really have a lot of meat on the bones in terms of process, but it does allow it. Is if in the real estate context, if you're foreclosing on a real estate asset, you can have a receiver appointed pending the foreclosure, so that asset's properly maintained. And for example, if you have a shopping mall, so that asset's properly maintained through the foreclosure process, and is operated along those grounds. And frankly, I'm unaware of anything in Colorado that would prohibit some sort of a thing that would mimic a reorganization through receivership. I find that less common, than you'd see in the bankruptcy world.
Right. So you mentioned foreclosure. I've seen circumstances where there are also just asset sales. A receiver can hire a broker, real estate business, and do a sale. Can you do sales like that in Colorado? And can you do free and clear sales in Colorado?
Sure, and I think the answer is you probably can. I think as far as I usually would break that up between whether you're dealing with real property or personal property. In real property, typically what is done is you go through the formal foreclosure process in order to satisfy lien rights and rights of redemption, all that kind of stuff. And you'd have the receiver appointed kind of in the interim to help maintain the value of the property while it's being foreclosed on. As far as personal property goes, if you're dealing with a business that doesn't really have as much real estate and you're dealing mainly with, personal property or leases or that sort of thing, the receiver can come in and operate that. To answer your question in terms of free and clear sales, absolutely. The receivership order will typically authorize the receiver to sell assets free and clear. And then you'd seek approval of each sale, and then you'd have an order approving that sale as being done free and clear, and you'd have to satisfy proper notice requirements to make sure all your lien holders and everybody are noticed that that's what's happening. But yes, you can implement a free and clear sale through the receivership process.
Are the title insurers in Colorado comfortable providing coverage when the transaction documents include a receiver's deed and maybe not exactly have the consent of the fee owner?
That's a good question. I haven't encountered that issue before. I don't know that off the top of my head. I haven't encountered that one way.
Yeah, I've had a mixed bag. Different states do it differently, and it's always really the decision of the carrier. But I'm just curious.
Yeah.
So obviously, when you have an operating company, maybe even a non-operating company, there's assets outside of the state boundaries. How would a Colorado receiver gain control of assets that are outside the borders of the state of Colorado?
That's a good question. You might have to have that receiver go into a state court elsewhere in order to go do that.
Mm-hmm.
You'd have to get jurisdiction over that outside of the state.
Right.
But there's no prescribed procedure for that here necessarily.
Okay. And obviously, a lot of this, it's time consuming, it's labor intensive. Frequently, you have to hire some people with very substantial expertise, whether it's in turnarounds or a particular industry or real estate. And it's important that those people be paid, that their attorneys, if they have attorneys, be paid. How does a receiver ensure that they will be compensated and be able to pay the costs of the receivership where there's a secured creditor involved?
A couple different ways. First of all, the receivership order will typically include a waterfall provision in it that talks about how assets get paid, and the receiver and his counsel are typically, and since it's the lender who's putting the receiver in place, that'll be somewhat of a negotiated document, particularly since you'll know who your receiver is ahead of time. And the lender will typically have the receiver and its counsel on top of the waterfall there. And so the receiver will know at the outset that at least it's going to get paid before the secure lender, because that carve out's made. And so will his counsel. The other thing that can be done is in Colorado we have receiver certificates, and that usually falls in my experience, third in the waterfall. But the secured creditor can effectively do bankruptcy equivalent's a DIP loan, but can effectively do a loan in exchange for a receiver certificate that would get paid on top of its own indebtedness if it needs to inject cash in order to finance the receiver's efforts through the receivership.
Could the receiver borrow from somebody else? And
yes, I'm sorry. Yes, absolutely. It doesn't need to be the lender itself who puts in the certificate.
could they get a priming lien in that circumstance, do you think?
Possibly. I would think the lender would have to agree to that, but yes.
Okay. Even if the lender was the entity initiating the receivership, you think they still would probably need to consent in order to be primed?
I would think, well, yeah, as a practical matter, I think so, because I think if it wasn't consensual, they could probably come in and object to the need for the financing in cash that would come ahead of their getting paid on the indebtedness.
Okay.
If that makes sense.
Yeah, it does. It does make sense. As I've done a couple of these different interviews, there are different experience levels in the courts. Some courts have very rare experiences with receiverships. Others have special panels set up to handle business disputes, including receivership. How is, and I'm not asking for, opinion or commentary that would be controversial, but how experienced or how frequently do Colorado judges see receivership cases, and how experienced are they with dealing with what can, I think, sometimes seem exotic to someone who's not in the insolvency field?
I think particularly, so the way Colorado is set up is we have courts of general jurisdiction that are set up in each county. So you have county district courts, and in smaller counties, there's no divisions, whether it's criminal or civil or anything like that. And so you may have a judge one day deciding criminal issues, and their background maybe as a former DA or public defender. And then, the next minute they'll be deciding civil issues. In some of the more urban counties, certainly Denver and along the Front Range corridor, you may have judges that see a lot more of both sides of things. In my experience, certainly in the urban counties, I think you have a lot of savvy judges who are well attuned to what's happening in a receivership, and there is no panel or anything per se. But my experience has been you can get a lot of judges who know what they're doing here.
So in the rare, almost unicorn level exotic receivership case where you actually are going to have money for unsecured creditors and you need some type of a claims process, how would that happen in Colorado?
The receiver would initiate that process, and again, the receivership order can govern how that process happens or when that happens. Typically, what I'll put in my receivership orders, at least initially, if I'm representing on the lender side or really the receiver side, is really only that you would initiate that claims process if it appears that there is money to distribute to the unsecured creditors, and because otherwise you're just spending money on the claims process for no purpose. But typically that's how that would be dealt with, and the receiver would send out notices of potential distributions, and people could assert claims and that sort of thing.
And there's one other topic that I know is very important, especially to receivers. And that is, obviously, number one, they're coming into a questionable situation. There's probably going to be some passion on either side. Sometimes people's angst can be turned on the receiver and they can become a target. What kind of protection does the receiver have in Colorado for the actions performed within the scope of their receivership order?
There's nothing statutory on that. So typically you'll have the receivership order itself, provide some sort of protection for the receiver, that if it's acting in its capacity as an officer of the court or, within the scope of what its authority is, then the receiver is not going to necessarily be personally on the hook for what it's doing in that capacity. There's also typically the receiver would post, usually it's not large, but a bond, to cover certain acts while acting as receiver.
And can whatever that protection is, now in Missouri, they get judicial immunity because they're an arm of the court. Other places it's case law driven. Sometimes it's at that higher level, sometimes not. But eventually they're getting discharged. And does it also occur that in the discharge order, there would be specific language that would say the receiver's protection continues after their discharge from this case.
Certainly, yeah, that would be well advised to put that in discharge order. Yeah.
Well, I'll tell you what, Adam, this has been very, very helpful. It's a great overview. And I would encourage anybody who watches this video and has Colorado receivership questions to give you a call, because I know, and I've talked to a number of people in other places, that this is a specialized field where you're going to want someone familiar with insolvency law as a general matter, and probably specific to that state's receivership process. Otherwise, you'll get tied in knots. And so I really appreciate you taking the time today to share with us this overview. And we will, of course, have a link to additional materials on Colorado receivership on the website at commercialreceiver.org. So thank you very much.
Thanks. And thanks for putting this together.
Yeah, sure thing.